Insurance. Landlord shall not insure tenant for any personal injury or property damage, including that caused by the act of omission or any other tenant or third party, or by any criminal act, severe weather, war, riot, flood, water leak, rain, hail, ice, snow, smoke, lightning, wind, explosion, interruption of utilities, insurrection, water, fire, or act of God. Tenant shall obtain and pay any insurance coverage by vendor approved by owner or agent, or can contact their own insurance company, that the tenant deems necessary to protect the tenant from any loss or expense that may be caused by such persons or events. Unless prohibited by law, tenant waives any insurance subrogation rights to the claims against landlord, owner, agent, and/or their insured. Tenant shall obtain and pay any insurance coverage that tenant deems necessary to protect tenant from any loss or expense that may be caused by such persons or events. Tenant shall not permit any act or omission which will increase the fire hazard or rate of insurance for the premises or any property thereon, including but not limited to the use of any portable heaters, any wood-burning stoves. Tenant shall obey all federal, state, and municipal laws and regulations, except as otherwise provided. If the premises are damaged by fire or other casualty event, a loss that is sudden, unexpected, or an unusual event, owner shall repair the damage within a reasonable time as defined here. At the owner's direction, may relocate tenant for up to 30 days in order to perform non-emergency repairs on the premises. Owner will provide reasonable notice to tenant under certain circumstances before relocating the tenant. If the premises are damaged to such an extent that the enjoyment is substantially impaired, tenant may immediately vacate the premises and within 14 days thereafter notify owner in writing to terminate this lease, in which case this lease terminates as of the day of vacating. However, if the damage was caused by a deliberate or negligent act of the tenant, his family, guest, or agents, tenant shall not have the option to terminate. The tenant shall be liable for all rent for the unexpired term of this lease, with abatement unless owner elects to terminate this lease, a right which the owner reserves in any event of substantial damage to the premises, by providing tenant with no less than 30-day notice of termination. Tenant has the option to attend a move-out condition report in the event tenant provides written notice to agent at time of move-out notice. Non-compliance with this section constitutes a material breach of the lease agreement. Liability. Neither owner nor agent shall be liable for any injury, losses, or damage to persons or property from any cause unless such damage shall be adjudicated to be a deliberate or negligent act on their part. Tenant shall give owner and agent prompt notice of any defect, damage. Tenant shall have indemnify and hold harmless owner and agent from all claims and shall protect his persons and his content on premises by insurance. Copy to be provided upon demand. Nothing in this lease shall constitute to relieve the owner of any liability to tenant under the law to the extent prohibited by the VRLTA. All personal property placed in the leased premises or any place appurtenant thereto shall be at the sole risk of the tenant or the parties owing the same, and the owner nor agent shall in no event be liable for its loss, destruction, theft of, or damage to said property. Tenants are strongly advised to obtain and maintain renter's insurance policy covering loss or damage of personal property at their sole expense. Non-compliance with this section constitutes a material breach of this lease agreement.